non-different manners.
That's no problem. That's no problem at all. Okay, who else do we have?
Your Honor, I had a case with Mr. Rowati and Mr. Curtis.
Read the summons.
What do you have? What case is it?
This is the Jensen versus Sims and Brown.
It's in the call 23. Jensen versus motion to transfer for lack of venue. Okay. Okay, whose motion is this?
Judge, this is my motion. I represent Ms. Brown. She's one of the defendants.
I know Mr. O'Reilly, I know you. Now, help me out here. What's your
Nothing. Charles Curry from Lexington. I represent Ms. Sims. And there is a typo in when I joined in this. I put Nancy Brown, and whatever Brown is should be Nancy Sims.
Okay.
Was that in the caption, Charlie? I didn't notice.
Yes.
Okay.
Well, I didn't either.
Yeah, apparently not.
So now,
You are human after all.
for Estill County to not, this isn't forum nonconvenience. This is saying that there's nobody, there's no.
All the defendants live in Estill County. They all live in Fayette County.
Judge, there's a memorandum Alex filed. I joined in it, and a response by Mr. Davis in the file, which points out the issues, I think, reasonably well.
Yeah, I think everybody knows what the issues are, Judge. And really, if I may, Your Honor, it really comes down to whether or not the court believes that an action which is at its core for specific performance is one that's transitory in nature, that is one that really doesn't rely upon any particular location. We've cited a case, the Caldwell case, that talks about the fact that specific performance is really demanding of an act. It could be performed anywhere. So the situs of the real estate is irrelevant to it. Now, if one of the defendants, any one of the defendants, had been either residing in Estill County.
What's the kind of case is it, first of all?
It's a specific
It's an amazingly
case.
similar case. It's almost this case in reverse.
That's right.
In that case,
What kind of case is this? First of
Real
all,
estate contract.
Yeah, real estate, yes.
real estate contract.
Well, that's I understand, Your Honor, that you're a little bit confused. What happened is that Ms. Brown and Ms. Sims entered into a land contract
on a piece of property
in Estill County. And then Ms. Sims entered into a real estate contract, purchase and sale, with the plaintiff for the same property, while the land contract was still in effect, had not been fully executed. So when the closing time arrived and came and went, and no closing occurred, Mr. Davis, on behalf of the plaintiffs, on behalf of the would-be purchasers, not the vendee, who's Ms. Sims, but the would-be purchasers, the Jensens, filed this action, which, as I indicated, Judge, at its core is for specific performance. In other words, what the plaintiffs want is the defendants to execute a deed to the plaintiffs for the particular property. And that's why we believe that this action probably lies in Fayette County, because it's one it's in personam in nature, it's transitory in nature, it's demanding an act to be done, and it's not affecting the title to the real estate. Now, Mr. Davis cleverly takes issue with that in his memorandum. Says that, well, we're asking for a declaration of rights. There are other things that kind of touch and affect the real estate. Therefore, venue under 452.
418-040.
Well, he's claiming under 452-400.
452-400. Because there's several little subsections in there in which cases involving real estate can be brought in or are to be brought in the county where the real estate is located. The Caldwell case distinguishes that, Judge. It says when you're talking about specific performance, when you're talking about you, Mr. Rowati, or you, Mr. Jones, or you, Mr. whomever, must do this or that, it becomes transitory in nature and really not about the real estate anymore. It's about demanding an act. That's what Carl was talking about. In that case, I believe the counties were Rowan and Fayette, weren't they?
Correct. Fayette County was filed.
Well, let me hang on.
Mr. Cottle lived in Round, the property was in Round, lawsuit
Laws in
Fayette, and the court ruled that Fayette had no jurisdiction. It had to be brought in the county in which Mr. Little, I believe it was, resided.
And he was also served with the process
And it
there.
specifically refers to 452-400 and says it does not apply. And I think to make this make a little sense for the court, notwithstanding the causes of action Mr. Davis has alleged, declaration of rights, quiet title, specific performance, and a tort. If you look at Chapter 452, I've got to leave it in. 452 is basically the venue statute. And it starts out with 452-400 is entitled Certain Actions Involving Real Estate. That would be the statute that you would claim jurisdiction lies in Estill County. Following that, there are 16 other provisions which give specific denominations for venue, like where you sue a board of education, where you sue on return of no property found, where you sue a bank or an insurance corporation, an action against the corporation for tort of contract, an action against tobacco growers and warehousemen, an action against a commentary. In other words, it goes 16 of them, it names them. Then there's a catch-up, 452-480, which is what we call popularly the transitory action statute. It's where you get service or where the defendant resides.
Anything that's not venue lies in any of the other statutes.
Right, and it specifically says, unless otherwise denominated herein, as a statute is transitory in nature, and service lies at the residence of the defendant or where you can serve the defendant. Just the opposite of that is 400, i.e. either 480, 452-480, or 452-400 applies. Mr. Davis obviously is saying 452-400. We're saying 450-480 applies. The Cottle case, as Alex has pointed out, directly addresses that, and it addresses the application of 452-400. And it says it is not applicable, that this is a transitory action under 452-400, and that therefore jurisdiction lay in the county of resident of the defendant, which in the Cottle matter was Rowan County, and the action had been brought in Fayette County. So the old Court of Appeals held that the Fayette County Circuit Court had no jurisdiction to hear the matter, and of course that was before we had the statute that allows us to move the case. So in that particular instance, it was dismissed and had to be refiled. Now the remedy is different. You have a statutory authority to transfer the case.
I don't have it in front of me, but 480, I understood you to say.
I believe I got copies.
400 and 480. I thought 480 was where the defendant resides or is served.
480 is the transitory case.
What was 400?
It's actions that relate to real estate.
Okay, it's where the real estate is.
Is where the real estate is.
Okay.
And at first blush, you might think that would apply, except for the Cottle case, Cottle versus Little, that's the statute 480. And I have a copy of the Cottle case at the court.
No, I'm with you. Mr. Davis, anything else?
One more thing. Mr. Brown, Mr. Duffy is now a defendant. He resides in Fayette County.
Correct.
Ms. Brown resides in Fayette County. Ms. Sims resides in Fayette County. The contract was consummated in Fayette County. So there's not like Fayette County is without any contacts in this case. And Mr. Sims entered a special appearance. We have not yet been served.
Okay, Mr. Davis, what about it?
Well, Your Honor, I think all well-reasoned arguments. The problem that we have with the motion, first off, is this. 452-480 specifically says Kentucky Transitory Action Statute that provides actions must be brought in the county where a defendant resides or is summoned.